Okay, so welcome to video 3, in which we're going to begin our discussion of trade secrets. And I'm recording this video here on Saturday night in New Orleans, preparing for the upcoming Hurricane Ida. So we'll see how that bodes for the rest of the videos for this week. In any case, we're going to be talking about obviously a bunch of different kinds of intellectual property in the course of this class. In the previous class, we talked about misappropriation of factual information. Now, on one level, trade secrets are related to misappropriation of factual information because, of course, trade secrets go to protect facts, right? But they go to protect a different kind of facts, right? So whereas in INSVAP and the other misappropriation cases we discussed, the question was whether or when it was a form of unfair competition or inappropriate business practices for a business to use facts that were gathered by a competing business in ways that were deemed to be improper under the circumstances. In the case of trade secrets, what we're talking about is when it's improper or unfair competition, perhaps, for businesses to take advantage of factual information that's valuable because it's secret and that they obtained from a competing business via some kind of improper means. Right. So unlike public facts, like we've talked about previously, trade secret law is about private facts. And the question is, what does it mean for them to be private? How private do they have to be? And what is a plaintiff in a trade secret action going to have to make out in order to bring a viable claim? Now, one thing to keep in mind as we talk about trade secrets is their relationship to patent law. Right? So in many respects, not all respects, but in many respects, trade secret law can and does protect the kind of information that might under some circumstances also be protectable by patent law. And as a consequence, the people who are generating that kind of information, or the companies that are generating that kind of information, sometimes have to make a decision whether they want to opt into a trade secret regime or opt into a patent regime, right? And we'll talk more when we talk about patent law, what that trade-off entails and why in some circumstances businesses might actually find trade secret protection more appealing, at least under some circumstances, than they might find patent protection. One obvious distinction between the two, however, of course, is that patents have a fixed term, whereas trade secret protection does not. And in fact, a trade secret can and does last as long as this information in question remains secret, right? So, lots of famous trade secrets out there, formula for Coke, right? The herbs and spices in Kentucky Fried Chicken, right? Those have been secrets for a long time and they'll stay secret. They'll remain trade secrets unless and until the secret information is disclosed in such a way that it becomes public information. Okay, so when we talk about trade secrets, what are we really talking about? Well, there are many different trade secret regimes, and so the subject matter of trade secret protection is going to depend, at least to some degree, on which regime applies under the circumstances. However, broadly speaking, we can look to the definition of a trade secret in the Uniform Trade Secret Act, which has been adopted by the majority of the states in large part or entirely. And so kind of gives us a pretty good sense of what trade secret protection typically covers. And it also reflects the fact that trade secret law historically was a form of state law protection, and in large part remains state law protection today, although there is now as well federal trade secret protection via statute as well, right? So we have both the Uniform Trade Secrets Act, which can be adopted by states in their own law, also federal trade secret protection law recently adopted as well. So multiple overlapping regimes, and that'll be a theme when it comes to several of the different kinds of intellectual property law we talk about in the class. In any case, two fundamental requirements for trade secret protection to attach, namely that the information in fact be valuable or commercially valuable because it's secret. In other words, it has to be actually secret information, and the owner of that information, the person who wants to assert trade secret protection, has to expend efforts to maintain the secrecy, reasonable efforts under the circumstances. Right. So two fundamental requirements with a lot of additional kind of subsidiary requirements attached to them. Right. So the requirement of actual secrecy has lots of associated requirements. Like, for example, if it's secret but easy for somebody to find out, well, then it's not really secret in the first place, simply because no one went to the trouble yet. And the propriety of the means also adds a kind of normative element as well. In other words, right, what does it mean for a means of ascertaining confidential information to be improper versus proper? What do we mean by that distinction, right? What's the quality of an effort to obtain information that would make that effort improper in the first place? And then the second requirement kind of has the kind of normative judgment-based element built right into it, right? In other words, what does it mean for efforts to maintain secrecy to be reasonable or unreasonable under the circumstances? Well, we're going to start our conversation by looking at the first question. In other words, what does it mean for information to be secret or confidential in the relevant sense in the first case? Okay, so classic case, Amoco v. Laird. What happens here, of course, Amoco is an oil company in the 1990s prospecting for oil all around the United States, looking for promising sites where they might look for oil. They have an employee named Williams who is tasked with locating promising drilling sites in essentially the Midwestern United States, areas around Indiana, Illinois, Ohio, Kentucky, and so on. Turns out, we learn later, there's quite a bit of oil and other forms of petrochemicals to be found there. In any case, Williams is poking around looking for promising sites to drill, using a range of different sources of information to do so, including maps and other kinds of information provided by the U.S. Geological Survey. Of course, this is publicly available information, but you have to know what to look for and where to go, and it takes time and energy to go through it. He also employs a range of different people with special skills and information to also be looking and gathering and processing information on his behalf. And among those people is a geologist named Clendening, right, who works for Williams and by extension works for Amoco. And Clendening is a big proponent of this microwave radar tool as a means of identifying where promising oil drilling sites might be. So essentially, after going through a bunch of potential places they might drill and identifying some regions that might be promising, Clendening talks Williams essentially into investing a bunch of money into getting these microwave radar surveys, and using those surveys, they further narrow down the potential places to look for oil. But it turns out there's kind of a slump. Amoco's like, well, maybe we're not sure that it's going to produce enough to be worth drilling there. We're going to kind of put it on the back burner and see whether we kind of have it in the pocket in case we need it for later, right? Clendening is disappointed. He really wants to be pushing this new technology as a way of locating oil. And of course, if they're not going to drill, he can't really say anything about how effective it was. So he goes out and gives information effectively to a competitor, right? So the Texas oil man by the name of Laird. Clendening tells Laird, hey, I happen to know that it's very likely that there's going to be oil if you drill in some of these locations. Well, Laird, of course, is thrilled to have this information, goes and checks them out, hires a dowser, among other things, to sort of further identify where he's interested in buying up leases, and ultimately goes ahead and does so, gets a bunch of oil and gas leases in the region. Fast forward a little bit, Amoco says, hey, now we're looking, we need some more supply. Let's go out there and start taking some of this stuff we've got in the pocket and start buying up some leases. Oh, already been purchased by Laird, right? So they're like, oh no, somebody else beat us to the punch and bought leases in places where we were otherwise going to buy them. That's really bad, right? How did this happen? And, doesn't take a genius to figure out that this guy Clendenning was responsible for giving the information to Laird. So Amoco brings in a trade secret infringement action against Laird, their competitor, saying that you obtained this information through improper means, right? You got this from a person who was our employee and who had that information because of his employment with us, and it was improper for you to get that information from our employee. He owed us, Clendenning owed us a duty of confidentiality. Well, what's Laird's response? Laird says, hey, no, wait a minute. This wasn't confidential information in the first place. There's no trade secret protection for me to violate. Why not? Well, this was readily ascertainable. I mean, after all, how did Amoco figure out where it might want to go and drill for oil? Well, it went and looked at the US Geological Survey. It read the different maps. It compiled information, right? It got these microwave surveys and used that information as well. And Laird says, look, if I had just gone out there and used the maps and gotten the information and done the survey, then I would have known exactly the same thing that you did. That's not secret. That's just you gathering information and then like basically reading the information to know what it tells you to do. The court rejects that, right? It says, look, readily ascertainable does not mean that it's economically possible for you to do the same thing, right? I mean, the idea here isn't that somebody else could go and replicate the efforts, potentially replicate the efforts of Amoco by investing a bunch of money in this expensive venture of figuring out where the promising places to drill are, right? Sure, that's true, but that's not what we mean by trade secret protection. The point is, essentially, Laird, you didn't invest all that money in figuring out this stuff. They did. And precisely what trade secret protection is intended to be providing protection for, right, is those kind of investments, right? It's like, why are they willing to invest this kind of money in developing this information and kind of having it available to use, right? Well, because they think that it's going to be proprietary information, right? Amoco invested all this money in figuring out where to drill and allowing people like Williams and Clendenning to have access to that information because it thought it would be the only company with access to that information, and therefore its investment would be secure. And Clendenning's disclosure of that information to Laird meant that Amoco's investment was no longer secure, right? Because Laird had now beaten them to the punch. Well, this tells us something important about trade secret protection and what we have it for in the first place, right? Basically, what trade secret protection is doing is recognizing that, in the abstract, there's a way you can always keep secret information secret, and that's by not telling anyone, right? I mean, if you have a secret, the best way to keep the secret is just not to let anyone know the secret information or even know there's a secret to know about in the first place, right? I mean, the more secret you keep it, the less risk there is of disclosure because no one's even going to know that secret information exists in the first place. The problem is, in a business context, in a commercial context, in order for secret information to actually be valuable, you frequently, if not almost always, have to be able to disclose it to somebody, right? You have to be able to disclose the people who work for you, because if you can't disclose it to your employees, to your agents, there's no way you can do anything with it. If you can't do anything with it, you can't realize the economic value. And that's the whole point of trade secret protection, right? The idea is it's protecting the investment, it's protecting the value, the commercial value, and the exclusive right to exploit that confidential information commercially. And how does it do that? It essentially does that by telling the agents of the business that you can't disclose or use this information without permission. Okay, well, that goes to the question of what counts as trade secret information, or other, what can count as trade secret information, and what's the difference between a trade secret claim and other kinds of business tort claims. So what happened in the Burbank Grease via Sokolowski? Okay, Sokolowski worked for Burbank Grease, right, which was a grease reclamation company. Basically, trucks, they go to different businesses, get the grease and refine it and use it ultimately for other purposes, right? The businesses want to get rid of the grease because they have to throw it away somehow. And Burbank Grease can help them with disposal. And then I believe they also kind of reprocess it to be used in other ways. Okay, well, Sokolowski quits Burbank Grease and goes to work for United Liquid. So at the time he goes there, United Liquid is not in the grease business, but Sokolowski, more or less, you get the impression, Sokolowski says, hey, I know the grease business. It's consistent with what we're already doing. Why don't we get into the grease business? I could really make that profitable for you, United Liquid, or perhaps United Liquid hired him precisely in order to do that. In any case, lo and behold, Sokolowski discovers that he has a bunch of customer lists and so on available in his house where he was working remotely that he obtained as an employee of Burbank Grease Services. And he starts using those in the context of working for United Liquid, and Burbank Grease figures it out when United Liquid starts stealing some of their customers, right? So their customer lists are used by Sokolowski in order to compete or enable United Liquid to, in effect, compete with Burbank Grease Services. And then the question becomes, can Burbank Grease bring an action against Sokolowski? Well, the intermediate court says no, right? There's no action that can be pursued here at all. And it does that by looking to the state trade secret law. And it says, look, state trade secret law does two things. First off, it says that it defines what counts as a trade secret, or it provides us with a set of tools for figuring out what counts as a trade secret. And in addition, it says that this statute preempts any common law claims that might otherwise, any common law trade secret claims that might otherwise be brought. Okay, so the first question here is, was there a trade secret to be infringed in the first place? And the intermediate court says ultimately no, right? What are we doing? What was a potential secret? Well, it was client lists, and in addition, information about client charges, right? Essentially what the clients were paying in order to get these grease collection services. And, is it possible for a client list or a rate sheet to be a trade secret? Yes, it is. It's possible, but only in the circumstance where it's actually a secret, right? So what's the problem here? Well, it's like, who are the potential clients? It's anyone who has grease for sale, or who has grease for sale. It's businesses that produce grease. Is that a secret to anyone in the grease trade who's making? No. Essentially here, anyone in the grease trade knows who these businesses are going to be. Okay, so the initial question of, who's a potential customer? It's like, well, you go through the yellow pages and you can figure that out pretty easily. You don't need the secret list in order to know who the potential customers are, right? But Burbank has another argument, right? They say, no. There's also data around how much we're charging. And that pricing data is also the kind of thing that could be the subject of trade secret protection? And the court says, well, yeah, under some circumstances, it might be, right? If that were information that was not readily ascertainable, right? Or not known to the consumer, for example. But here, like the pricing information is just how big is the tank and how much grease is there. And, you apply the numbers and it spits out, whatever the result is. That's not secret either. Right? Like, that the formula is not a special formula. You can't claim trade secret protection there either. And then the intermediate court says, okay, look, based on this interpretation, there's no trade secret to be infringed vis-a-vis these client and pricing lists. And the preemption provision says you can't bring any other kind of claim as well. In particular, you can't bring a breach of loyalty claim against Sokolowski for leaving your business but keeping this confidential information in violation of the agreement that he had with you. So the Wisconsin Supreme Court then takes up the question of whether or not the other business torts, whether or not the duty of loyalty claim was preempted, and it says no. Why not? Well, it looks at the statute and says, hey, the statute preempts trade secret claims and only trade secret claims. Well, you just said, lower court, that this was not a trade secret claim because there's no trade secret to be infringed. If there's no trade secret claim and the only thing that's preempted is a trade secret claim, then whatever claim is being made must not be a claim that's being preempted. Presto, that easy analysis there. The duty of loyalty claim is different because it's only applying to things that don't satisfy the requirements for trade secret protection. Now, perhaps a little excessively clever, right? But it does at least suggest that perhaps we should think of trade secret protection as being a unique kind of tort in counter-distinction to other kinds of business court. Now, is that right? Is that the correct way to think about it? Interesting question. Maybe reflect on whether or not you agree. Okay, so in addition, there has to be an improper method of obtaining the information employed. Now, in the previous cases, the improper method is in effect hiring away employees from other companies that are in possession of that information and getting the information that way. In fact, that's kind of the thread that goes through most trade secret protection claims. The reality is that in a lot of ways, trade secret protection claims are really about employee non-compete clauses in a lot of ways, right? How do most companies get trade secrets improperly? Well, by hiring someone who happens to know the secret information in question and asking them to disclose it. Okay. However, there are lots of ways of getting the information that are not improper, right? I mean, you don't have to get it from an employee, right? You could figure it out yourself, right? You could look at their product or whatever it is that they're doing and sort of read backward, reverse engineer what they've done in order to figure it out. You could just see what they're doing, right? You can see what businesses they're going to and figure it out, or go out and see what other people have to say about it. Lots of different ways of figuring out information that isn't improper. Okay, key one, reverse engineering. That's always been taken to be a proper means of figuring out information, right? The idea is that trade secret protection only protects things that are secret and can't protect things that aren't secret. And if by virtue of selling a product, you're making it clear how you're achieving whatever it is that that product does, that's not a secret anymore. And trade secret protection can't protect that kind of secret. If someone can figure it out from the nature of the product itself, then it's not a secret. And in fact, your own product is telling on you, as it were. Your own product is disclosing the secret, and you can't stop it, right? Trade secret law isn't there to stop it. Okay, so what happened in Cemen v. 3D? Well, we've got two different businesses that are both in the cement mixer game, right? Cemen has an employee named, oh gosh, what was his name? Well, I forget. Anyway, Cemen has an employee who ends up going over to 3D Industries, right, and bringing information about Cementech's new mixer along with them. Now, of course, these two companies have some history, right? 3D was talking about buying Cementech. It didn't end up going through, right? But they ended up buying, or essentially hiring away an employee instead. Presumably they said, hey, the real value here is not the business, but rather some of this knowledge associated with the business. That's what we really want. And if we get it cheaper by just hiring an employee, all the better. So what really happened here, Cementech has a brand new cement mixer product, sort of their new, presumably their new flagship, their flagship model. They release it, and 3D Industries almost immediately comes out with its own new mixer product that's essentially the same as the Cementech one. And Cementech brings a trade secret infringement action against 3D, saying, you got the information about how to make this mixer from our employee, right? That's a trade secret violation because it's improper to get the information from our employee who promised not to disclose. And 3D says, hey, no way, man. Like we could just as well have reverse engineered the mixer that you sold to the public, right? All we had to do was, just like anyone else, go out and buy one of these mixers and then take it apart and figure out how it worked. And we'd be like, oh yeah, of course, like what a great idea. This is how it's done. If you're selling a product to the public, your competitors can buy the product just as well as members of the public can, and they're perfectly entitled to reverse engineer it. It was possible for us to reverse engineer, therefore there's no basis for a trade secret claim. Court says not so fast, right? Cementech brought in an expert that said, yes, reverse engineering is possible, but you couldn't do it that quickly, right? 3D brought their product, their competing product, onto the market more quickly than they could have done had they had to reverse engineer the Cementech machine, right? They were able to do that because they got the trade secret information improperly from the employee rather than through reverse engineering. That gave them a jump on the market, right? That rightly belonged to Cementech, and therefore Cementech can bring an action for trade secret violation based on the improper acquisition of the information, even though 3D could have gotten it properly via reverse engineering. Okay, so it's not just that the information could have been reverse engineered, but also that the information was in fact reverse engineered as opposed to obtained in some other way. And then finally, the casebook talks about the DVD copy control versus Bunne case, what happened there. This is back in the day when physical media still ruled, and companies were trying to figure out, essentially movie distributors, movie studios, were trying to figure out how to prevent people from copying DVDs, right? They were worried about losing profits from people copying and selling bootleg DVDs, cutting into their market for the retail market for DVD movies. And so they developed a software solution that would be embedded into the code on every DVD that would prevent that information from being copied. Very clever, right? This kind of copy protection software, and it took something like 3 days for hackers to reverse engineer and develop a tool for avoiding this copying, this anti-copying software, which they dumped on the internet and started immediately distributing to anyone who was interested in it. The studios went bananas. They were apoplectic about this. They did everything in their power to try to stop it, including anyone who was circulating it. They sent them a cease and desist order and tried to get an injunction to prevent them from doing so. This was seen within the computer community as being a really egregious First Amendment violation. And so people started doing things like producing T-shirts with the code on it and so on and so forth, as a way of essentially thumbing their nose at the movie studios. Anyway, for better or for worse, they continued to pursue this particular action against one individual, many individuals, but this one individual in particular who was continuing to disseminate the DCSS code that could be used to counteract the copy protection software, saying he knew or should have known that this was a trade secret and was distributing it anyway. This is a problem. And the court essentially says, look, it's not a secret. It's available to millions of people. Everyone already knows about it. You can't bring a trade secret claim against someone who obtains improperly obtained information, insofar as, you know, reverse engineering under the circumstances was deemed it was deemed improper. Obtaining this DCSS code was deemed improper, right? He didn't get it. You haven't shown that he got it through improper means. He got it because it was available to the public. And you can't use a trade secret claim under those circumstances, right? It's not secret anymore, right? Maybe it was at one point, but it stopped being secret, and it stopped being secret before he had it, right? And therefore, he's not the kind of person who can be a defendant under the circumstances.